call this meeting of the Town of Clayton Board of Adjustment meeting to order. First item on our agenda tonight is any adjustments to the agenda? Staff, any adjustments to the agenda this evening?
We have no adjustments to the meeting this evening.
Thank you.
Can you just state how members that are not here today?
Yes. And for the record, we have two members that are not here tonight. Board member Bob Satterfield and board member John Salupo. All other members are present. Okay, with that, we'll move to item 3, approval of the minutes. And I assume everyone had a chance to review the minutes. And if there are any corrections, please let them be known. Matt? Any questions?
I make a motion to approve the minutes from last meeting.
You have a motion to approve. Do we have a second? We have a second by board member Perricone. All those in favor say aye.
Aye.
Opposed, like sign. Motion carries. Okay, moving forward now to item number 4. This item will not be heard this evening due to lack of a quorum of qualified board members. This is an interpretation by our town attorney, and we will ask, if no one objects to the board, that we continue this to our June meeting. Are there any objections to that? Okay, hearing none, we'll continue that item to the June Board of Adjustment meeting. Moving now to old business, we'll turn the meeting over to Attorney Raspberry for some additional board training.
Thank you, Mr. Chairman. Let me first apologize for being late. The issue that arose just yesterday and today regarding the ability of the board to take action on the single case that was scheduled to be heard, we sent extensive expressions of our opinion on the question of voting qualifications of the alternate ETJ members with respect to this particular case. Be happy to discuss the particulars of that with anyone at the appropriate time that would like to know. We copied staff extensively and also the chairman, but if anyone is interested to see the thinking behind that, it came to our attention yesterday afternoon that we did have an in-town case and that there would be 2 absent members, and that did present a problem as to the qualification of the alternate members who, the fact that 2 absent members represented the town of Clayton itself. They were within the corporate limits members. And the requirement by statute was that there be a town ordinance qualifying the ETJ members to vote on all applications, not just the ETA applications. And the ordinance that the council adopted just 3 or 4 weeks ago, establishing and constituting this board, did not have the required language in it that would authorize and empower the ETJ members, alternates and regular members, to vote on a case involving an in-town property. And the end result of that was, together with the absences that you have tonight, is you just didn't have the 4 votes that would have, 4 qualified votes, if you will, that would be required to approve a variance. And that struck me as being very unfair odds from the applicant's standpoint. So it obviously made sense to continue the case and to deal with this procedurally. Hopefully that can be addressed by an ordinance change and the case can be taken up promptly at the next occasion Board of Adjustments meeting. But that's what's been going on. That's the reason I was late, because I planned on doing a little brushing up on training during the late hours today, and other things came ahead. So I got a late start from Raleigh again, but we won't make a habit of this. Thank you.
Understood.
And just as a thought, with the way the ordinance is crafted currently, there should be some consideration to a reciprocal amendment that it also includes the same type of scenario should the extended jurisdictional area become a subject of a variance as well. Just so the votes are covered both ways.
Well, I think that's right. The town-appointed members, or those members representing the town, can vote on cases involving either property in the ETJ, but not in the town, but also property in the town. So the in-town representatives are fully authorized to vote on all cases. It's just the ETJ representatives that have a problem with respect to in-town applications, unless the ordinance empowers them to vote on all cases and problem is solved, if that is done.
Understood.
And frankly, this is a problem. Whenever there is a 5-member board, 5 is the minimum allowed by statute. With a 5-member board, not having the ETJ representatives authorized to vote on everything just presents a problem very frequently. Right. You have this problem a lot.
Right.
All variance requests would require a unanimous vote, even if there were no absent members. But if there's an absent member, you've really got a problem with an in-town.
Right.
You either can't vote or you got to have a unanimous vote. So it needs a fix, obviously.
Understood. Well, thank you for bringing that to our attention, Raz. Do you have training materials for us further?
I do, and I thought since we're here, I'd pick up generally where we left off at the previous training session, and I realize in retrospect that we probably tried to take on too much in too short a period of time, and I probably was fine-tuning the presentation a little more than it needed to be at the first get-together of the board. So what I'd like to do is go back to that outline, hit a few high points that I think are worthy of some discussion, answer any questions you may have, and to just take the training session where you all would like to have it go.
I think so. Everybody in agreement with that? Sure.
I did find one UNC School of Government article that I don't think I had sent to anyone or that was in the package that we handed out at the previous session, but I do have a Coates Canon from the UNC School of Government on variance standards, what is a hardship and when is it unnecessary. It's a real good article. As you all know, the general statutes impose 4 standards or findings or requirements that a local board has to meet in order to grant a variance. It's in General Statute 160D-705D, and that language, the statutory language, is repeated verbatim in the UDC of the town. But just by way of review, when unnecessary hardship would result from carrying out the strict letter of a zoning regulation, and I would say it also applies to other developmental regulations of the town. It's not just zoning variances, but the law now allows variances, specifically allows variances from essentially all of the land use regulatory requirements of the town. When unnecessary hardship would result from carrying out the strict letter of a land use regulation, the Board of Adjustment shall vary any of the provisions of the regulation upon a showing of all of the following, 1 through 4. The first is the most important criteria. Unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate in the absence of a variance, no reasonable use may be made of the property. So it's not necessary for the applicant to show you that without the variance, the applicant is left with a worthless piece of real estate. There may be lots of other options, but that is that does not preclude the reasonableness of you all granting a variance. Number 2, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstance as well as hardships resulting from conditions that are common to the neighborhood of the general public, may not be the basis for granting a variance. Obviously, personal financial challenges, significant additional expense being necessary in order to meet the requirements of the UDC, any kind of individualized economic distress that the applicant is in, those types of things are not to be considered. You are to consider hardship that results from the property itself and the classic attributes or examples of or location, size, topography, shape, its location relative to other properties, those types of things, physical attributes of the property that's the subject of the application. Number 3, the hardship did not result from actions taken by the applicant or the property owner. The hardship may not be self-imposed. Classic example of that is if a property owner builds a structure that causes the footprint of the structure to be very close to the side yard lines or any of the setback lines, and then seeks a variance to construct a garage or an addition, the lack of a satisfactory setback is due in large part to the fact that this original structure that the owner built was put pretty close to the property lines to begin with. The statute goes on to say that the act of purchasing the property with knowledge that circumstances exist that may justify the granting of a variance is not a self-created hardship. So,
Say that one again.
surely, the fact that the applicant purchased the property and knew about the conditions of the property that made a variance necessary according to what they're contending, that is not a self-created hardship. In other words, you can buy the property, you can buy property with knowledge that there's a problem, but that doesn't mean that you've self-created the problem. You can still seek relief through a variance, even though you purchased the property knowing about it. Now, that's different from maybe building the house in the wrong location or other kinds of actions that fall within the category of being a self-created hardship. But just buying the property with knowledge is not enough to be a self-created hardship.
How is leasing viewed in that? Is leasing, could you,
Well,
it's a bundle of rights, right? So is leasing
Sure.
considered purchasing, is it akin to that?
I think the same principle would apply. I mean, a tenant with the consent of the owner can be an applicant as a contract purchaser. Someone that has a purchase right up to the property can bring a request for a variance. The point, I think if anything, a tenant would have a stronger argument that entering into the lease with knowledge that there was a problem is not a self-imposed, self-created hardship kind of circumstance. And then finally, the catch-all standard number 4, the finding that is required to be found is the requested variance is consistent with the spirit, purpose, and intent of the regulation such that public safety is secured and substantial justice is achieved. Obviously, that's a very, very broad, squishy kind of finding, but it is a catch-all, and there may be circumstances where the other standards are met, but you still feel troubled. And but that's the standard where the application as a whole, the property as a whole, any other more far-afield factors can be considered in deciding that, you know, it doesn't hurt anyone, it doesn't hurt the public, there's no safety problem created, it sounds like a reasonable request and a good idea, and it advances it's not inconsistent with the overall spirit of the land use regulations of the town. So those are the 4 standards, and those standards for taking action on a variance request are the real focus that the board should be making in all of your cases. Your chairman called yesterday afternoon late, and we discussed the agenda to the meeting. Generally, some of the principles of order and how the meeting would progress and so forth, and how to get to the decision-making process after the evidentiary hearing is closed. And I suggested to Marty that, well, the best place to start looking is to pull out these findings and have the committee members, have the board members ponder what evidence they've just received and say, okay, well, yeah, the applicant made these points regarding hardship, and they seem persuasive to me or not persuasive to me. Just use it as sort of a box checking exercise.
Now, as a matter of clarity, all or some or many, or how many of these conditions need to be met? That's
All.
right.
Statute reads upon a showing of all of the following.
Right.
Now, it's a little tricky because some of these standards are in the negative. So you will find as to standard number 3, it is not a self-created hardship. So it's not an affirmative finding with respect to the application. It's just that this place where an application could be tripped up, there are no worries there. That's not going to make it impossible to grant the variance.
Right, there's,
Or improper,
I
I
don't
should
know
say.
if you have this or not in front of you, but this was on, I think everybody's desk when we started, right? They actually restated on the next page, which is helpful.
Exactly.
How it's restated as
Exactly.
positive. So that actually is helpful.
Absolutely, absolutely. Yes. Right, right. Of course, if you found finding number 4, that is, it is stated differently than the statute is drafted. If you find, if 4 is answered to a yes, that leads you to a denial conclusion. Anyway, that's the way to focus the mind. That's the way to I think, approach these cases. And the context in which that fits is that all of your decisions will need to be backed up by formally adopted, written findings of fact, conclusions of law, and decision. Those 3 terms are straight out of the law books. That's exactly the way court orders and judgments are drafted. And as I mentioned at the previous session, sometimes the labeling is important. Sometimes the legal jargon is important. You all will receive evidence. That is, folks will come and offer testimony. They'll present written materials. They'll have documents. They'll have graphs. They may have photographs and so forth. That is evidence that you are receiving, and part of your job will be to consider all that evidence after a determination is made if it's to be allowed or not, if it's admissible. But assuming it comes in and you hear it or you see it, you will determine what credibility to give that evidence and how much weight to give that evidence. Some of it you may toss because you don't think it's persuasive or not particularly relevant, or whoever offered an opinion about something, for example, just didn't seem to have qualifications or know what they were talking about. But after you've sifted through the evidence, you then decide what is to be believed and what is to be useful and helpful and probative as far as these 4 issues are concerned. And you decide from that evidence what findings you will make. And it's an iterative process. You'll take all of this material and it'll be a matter of reducing what you have heard to just the little nuggets that lead you to the decisions that you have to make. So from evidence comes findings of fact that are important to lead you to a conclusion about the case in the context of these 4 findings. Occasionally, you'll have a finding that just sets the stage, that just gives necessary background information. It won't necessarily be pivotal in terms of making these connections, but you take evidence that leads to the findings that you make, and the findings will direct you toward a conclusion of law. And these 4 standards are mixed matters of law and fact. They are law because they're in the statutes, and they're pivotal, and they have legal consequences. So that's why the important determinations you will make relate to facts that say, yes, there is hardship, or no, there's not hardship. And the hardships relate to the right things. They relate to the property and not to the individual or circumstances that aren't to be considered, not self-imposed, and that are self-created hardship, and then that the variance makes good sense under the code and in light of the public safety and welfare considerations. So that is the process. And I think in most or many and hopefully most of your cases that relate to variances, at least as contrasted with administrative appeals, which you also may hear, but that's what's not before you now. As to variance requests, the issues are fairly simple and straightforward. They truly are. And I think you all, through your deliberative process, I suggested to Marty that perhaps an appropriate way to manage this after a hearing is closed and to get to the decision is to, first of all, close the evidentiary hearing, and then open the deliberative phase of the hearing. Legally, in theory, the members, those in attendance who have spoken or that may want to speak they don't have the floor at that point. And following Robert's rules, you all figure out how you're going to decide the case. And, Marty could just generally introduce the deliberation by summarizing some of the evidence that he's heard, some of the things that he took note of, and then he might ask individual board members what their thoughts are on what they've heard and the case in general. And in that way, I think the board, you all and the chair will get a sense of which direction you're heading. And it may be obvious in many or most cases that there's a consensus to either grant or deny, or to grant with conditions.
So that part is kind of like just an open discussion?
Yes. Yes. Well, obviously it's not a round robin, but generally I think the chair would probably just take each member in turn. There may be questions that board members want to just discuss. There's no formalized procedure or order in which you should tackle evaluating the evidence and making your decision. One avenue that I have seen that works fairly well is for the chair to just ask members in turn what they're thinking, what their reactions were to the evidence that were presented. And it becomes pretty clear that there are 2 or 3 pivotal kinds of determinations you need to make, 2 or 3 things you're looking at real closely. And it's, like I say, it's a narrowing process, and in most cases, it'll go fairly quickly. And gosh, I had a Raleigh Board of Adjustment case just last week, and listened to a fair number of the other cases that were heard. And at the end of presentation of evidence and the statements or arguments that the parties made, the chair said, anyone have comments they want to make? Any questions, any further questions that we need to discuss? Silence. The chair said, does someone want to make a motion? I move we approve the variance. And that was it. Seconded and voted, carried unanimously. And that's I guess that's not uncommon. And that's a good segue to, at least in my experience, one of the real challenges of doing quasi-judicial work at a local government level. Courts have a unified set of rules of procedure. The lawyers have been there, done that. The judges are all attuned to a formal set of rules. And local government quasi-judicial cases just can go all over the place. There is no unified set of rules or customs. And attorneys who appear before boards of adjustment, the number 1 rule is assess the scenario. And then number 2 is to do everything you feel like you can avoid doing in order to protect your client, to maintain due process standards, and to advocate your case as best you can, but do everything you can not to act like a lawyer while you're doing it. And it's particularly true in a setting like this. You may have cases where it is kumbaya and it's fairly obvious there's no opposition. There may be very strong evidence in support. There may have been conversation in the public about the case. And it's old home week and there's no contentiousness and lawyers aren't lawyering and the parties aren't squared off with one another. It's just, it's family affair. But then you may have one case in a dozen or perhaps many more where the parties, it's controversial. The parties have lawyered up and you've got upset neighbors. And then it's necessary to get a little more concerned about formality, behaving professionally, watching being very careful regarding procedure, receipt of evidence, questions that are allowed or disallowed, and keeping the lawyers in check and so forth. So that's one of the challenges, is striking that balance, because you want to have some uniformity in the way you conduct your business, but there is going to be a good bit of variation as well between the very simple, straightforward, happy-go-lucky cases that are not controversial and those that are the other kind.
Now, through our deliberation, do we have to reopen the quorum back up if we have a question for staff or for the applicant?
Yes, that's a very important procedural point. When you take a case up, there will be two components. Well, let's look at the meeting agenda at large. You will generally open up with just a business session. You'll announce the meeting as being open, and this is a meeting. It's not a hearing. This is a public meeting that you're having to conduct the business. It may be to grant a variance in the case or make an adjustment to the agenda or to approve the minutes. There may be lingering question concerning a case that you previously heard about adopting findings and conclusions and so forth. That can take place in the business session. It's not part of the evidentiary hearing. As soon as you get through all of that, the chair will, without objection, announce that the evidentiary hearing is declared open. And that's when you'll start taking up the cases. Typically, you'll take old cases first, and then you'll go in chronological order with the new cases. Call each case. Normally, the staff will summarize the case briefly, pointing out the facts, what the applicant is seeking. And this is in the discretion of staff, whether they want to have any supplemental materials, photographs, maps, that kind of information. And the applicant then will be recognized to present the case. All the witnesses that may be appearing in that case need to be sworn, and that would also include members of staff if they're going to be offering any factual matters that could be considered as evidence in the case. So far and away, the best practice is to have the staff sworn in. The group I represent in Raleigh, they swear the staff in just as the evidentiary hearing is conducted, because the staff will be testifying, presenting information as to more than one case. It makes sense to swear in the applicant or any other individuals who may want to be witnesses in a particular case as a group, as that case is called. I've seen it attempted where you try to get all the public that shows up that may be testifying in any of the cases. And this, you can sort of see what's the best system here. If there are only two cases and you've only got 3 people that are going to be speaking in all the cases, you could just have one group swearing in. You need to call out all the names of the individuals who will be speaking, not just have a gang raising their hands and saying, I do, and leave names. But after they are sworn in, then the applicant typically goes first. The applicant will again summarize the case, offer evidence or statements of contention concerning their request for a variance. You then, once they are done, you then allow for questions from the individual board members of the applicant. And if there are more questions, then the chair calls for others who are present and desire to speak to come forward, asking for those in favor of the application first. Go through that same process if other folks appear and testify. And of course, they can testify and offer written material as well. Other evidence, they need to have it introduced into the record. Then after all of the parties present who have chosen to speak do their thing, you ask if there are any other questions that the committee members or the board members have of anyone that has spoken while the hearing is still open. And if there are no further questions, close the public hearing. Then you go to the deliberation phase. If in the course of deliberation, this is not uncommon, some issue comes up for discussion and a board member thinks, well, you know, I'd really like to hear what the applicant or what one of the speakers had to say about this point. It's well within the discretion of the chair to reopen the public hearing. And typically the chair would just say, unless there is an objection from the board, I'll reopen the hearing. And then when the Q&A is done on that sub point, the chair will say, unless there's an objection, I'll now close the public hearing again. The applicant has the burden of proof. The applicant has the right to present rebuttal evidence if there is opposition. It may be that if it gets to be a give and take and the applicant makes a point and on rebuttal and then someone in the audience wants to, or a presenter wants to be heard again, it's within your discretion to allow basically a cross rebuttal. It's discretionary. At that point, once the one rebuttal is allowed, you don't have to keep the show rolling. You can say, I think we've all heard enough. But again, the key point is the applicant gets to open and close in the presentation of evidence because the applicant has a burden of proof.
What about on-site visits? How does that conducted as far as like, from my position, if I feel that we need, you know, that I want, or I think that we need I see you shaking your head, yeah. On-site, how does that work as far as, I'm the only one, or does everybody have to agree, or?
No, you are perfectly at liberty to inspect the property in advance of the hearing. Now, the one point that can't be overemphasized is you should be very cautious and I don't think you're allowed to go inside structures. I think the best practice is not to go inside structures, and usually you're going to just be looking at exterior elements. But that's an occasion where the owner or an occupant or someone interested in the case would just love to engage you in conversation. And it is extremely important to politely say, not to be unfriendly or discourteous, but it's been preached to me that I should not have a conversation even about superfluous things with an interested party in this case. There's a due process right for a fair hearing, and that means, and that includes that there should be no off-the-record contacts or communications between the decision makers and the parties that are interested in the case. So I would say a drive-by viewing is acceptable, but be very careful.
What about as the case, so what about as we're hearing the case, but I feel now that, hey, you need to go out there and take a look at it. Are we able to do that?
Well,
Or we'd have to put off?
I mean, normally it's customary to make the decision on the first occasion of the hearing. Normally, these things don't trail out to multiple hearings. I'm presuming that in the materials that you are provided in advance of the scheduling of a case, you'll have a synopsis. You'll have the name and address and what's being sought. So you'll have the information that will allow you prior to the initial hearing to take a look if you feel that's something you'd like to do. If every member can make requests to defer final decision on a case or to put off deliberation because you may want to take a second look at the property. I mean, there's nothing wrong with that. You have discretion to do that. That's just a mechanical and a procedural kind of.
Would that be done through a motion? Would that be done through a motion?
I'm sorry.
Would that be done through a motion?
Yes.
Okay.
Yes. I mean, I think yeah, board member that has concern and wants to see the property post-hearing after they've heard evidence, perfectly okay to say, Mr. Chairman, I'm really concerned about this point. I'd like to take a second look. I would like to make a motion that we postpone making a decision on this case until the next meeting of the board.
Probably be a word of caution about how many people meet the board.
Very good point. It is clearly a violation of the open meetings law if a majority of the board, so that would be 3 or more, gather together at the same time. Looks bad, and it will be an open meetings law violation. So I would say go out individually or maybe double up, but no more together than that, if you want to take a look at the property. And again, steer clear of any contacts, communication with the folks there. If you, I mean, obviously you can be friendly and such, but it just, conversations have a habit of creeping into substantive areas when you're making conversation with the owner or the applicant.
Raz, if there's insufficient evidence, if there's a question and nobody has presented anything to it, is the only option at that point to deny, or can you point out that there's insufficient evidence, and does that allow the board to continue the what's going on, or does the applicant have to request the continuance?
All of y'all's questions led me wonderfully to about the 4 points that I really wanted to revisit and emphasize tonight, and that's definitely one of them. The applicant has the burden of proof. The applicant has the obligation to make his or her or its case. It is not all that unusual for there to be a case that you can determine enough about just looking at the application and see what is being asked for, but the applicant does a lousy job of offering evidence to support it. And commissioning board members sometimes are tempted to fill in the gaps, or during deliberation to become advocates, or maybe even to become evidence presenters. And that's something to watch out for, because you're judges and jurors, and you're supposed to be detached, and you don't have sworn testimony to offer. You bring your expertise to the hearing, but be careful about substituting for evidence that just didn't get presented. The Historic Preservation Board I represent with Raleigh, that's not an uncommon circumstance. And what that board quite often does is to just send a signal or state directly to the applicant that, we really haven't heard enough on this point. We were looking for something like that would address the point, in this way, but we haven't heard it tonight. And, we would not like to necessarily to make a motion that you haven't met your burden on this point, but we'd like to just send a signal to you that we need a little more evidence on this point. We need more persuasion. So we'd like to defer the case until next month, at which time you can see if you can bring us some additional evidence that would address some of these concerns we have. So that's one way of handling it. But yes, indeed, the applicant's supposed to make the case, and it's not all that rare an occasion where the applicant just hasn't been a very good advocate for his own case. So that is one way of handling it. But if in fact you just don't hear it and it's not forthcoming, and you think that there just simply is a dearth of evidence in the record on one of the findings that you've got to make in the affirmative in order to grant the variance, then it's denial, and the finding in support of that would be the applicant has not met his burden of proof of offering us convincing evidence that shows unnecessary hardship, as that term is is construed as a matter of law. So that's, you know, that's not to get too legalistic about it, but just, you know, just tell them we need to see more is a way to address that, I think.
How common is that?
The Raleigh Board of Adjustment lately has been extremely, liberal is not the right word, flexible. They want to do equity, and the vast majority of the cases get approved, variances are granted. Didn't always used to be that case. Raleigh used to have some real gadflies on the Board of Adjustment. He would ask tough questions, and it was a toss-up quite often. Strict standard of hardship. But
That's how the language lends itself to be a strict interpretation.
yeah, it's the kind of thing I think the philosophy of this board will become evident
Right.
after you hear a few cases. The burden as it is measured by the Raleigh Board of Adjustment has not been a very high burden lately. You all may set the bar at a different level. That's just something you have to determine. And that's just my own editorializing. I mean, others may have a
That's what I'm asking for.
different view. But yes, it is a very subjective set of standards. And as formalized as you make this process, it's never going to be an objective ruling. It's not going to be something that is coldly objective and analytical. These are broad determinations you have to make. And do the best you can to back it up with concrete facts. Well, concrete findings, I should say. So let's see if there's, I haven't looked at my prepared notes yet. Let me, the one point that I discussed with your chair yesterday is a really annoying lawyer's kind of a footnote, but it's something I haven't been able to figure out a good way to finesse it. The NC State Bar in 2007 issued a formal ethics opinion that quasi-judicial, local government quasi-judicial hearings were court-like and judicial enough as to require lawyers to represent parties and to do what lawyers do in these kinds of quasi-judicial processes. And if an application is submitted by an individual property owner, no problem. The individual applicant owner is always allowed to present their own case, to present their own evidence on and for themselves without limitation. However, if your applicants are business entities, corporate entities, partnerships, LLCs, and the like, the bar opinion indicated that if they have a spokesperson that is holding himself or herself out as representing the applicant, the business applicant, and when I say representing, I mean representing them and doing the kinds of things that lawyers do in judicial proceedings, which is introduce evidence, ask questions, summarize a case, offer arguments, those types of actions are the kinds of things that require lawyers in the courts. And the chairperson of the board, if there is a legal counsel at the board, the lawyer has an ethical obligation to speak up and point out to, just say, a manager of an LLC that gets up there and says, I'm representing my company, and starts presenting a case. the lawyer has an obligation to say, well, you know, this could be an unauthorized practice of law, business matter, and there's a formal ethics opinion, and you're supposed to be represented by a lawyer. The way that we have gotten around that, I say we, the way the Raleigh Historic Preservation Commission that I represent has gotten around that, is in those cases where you've got an applicant that's a business entity that doesn't have a lawyer, I would begin, I would, as the speaker takes the stand, I would offer a comment, and I'd point out very briefly this bar rule and indicate that one way to accommodate that rule is so long as the presenter understands and accepts that he or she is not appearing to represent the applicant in the sense that a lawyer would represent an applicant, that they are appearing only as a fact witness to offer factual evidence and to answer questions of the board. And they all say, sure. Sometimes they skirt into making arguments and so forth, and you bite your lip. But that's, particularly the historic preservation crowd, that make great sense, because everything that's going to be done in a historic district has to get a certificate of appropriateness. And you'd be telling, you got a lawyer up to put a walkway in your front yard in a historic district or any other minor sorts of thing. Variances are exceptions, and usually the stakes are a little bit higher and so forth. So Cary, for example, in Raleigh, they require lawyers to represent corporate applicants, LLCs. You all can decide, and as you look at rules of procedure, what you want your practice to be. It's worrisome to me that in some of these relatively small scale variance requests or low stakes cases that you tell a party they've got to pay a few $1,000s to a lawyer. But that's what goes on in Raleigh and Cary. And as often as not, the lawyer takes the stand and introduces themselves and just say, I'd like my first witness to be so-and-so, and that individual who's the architect in charge of the work or principal in the corporate entity will get up there and basically do exactly what they were going to do before the lawyer made the speech about, about the bar rule. So, it bothers me a little bit, but that's to me, that's the way I have decided to handle it before the Raleigh Historic Commission. If you're comfortable with that, fine. If you want to take a little title line, that is fine as well, but that's something that tonight I was prepared, understanding the applicant was an LLC, to offer that intrusive lawyer commentary, 30 seconds before the hearing. Ask if they accept that they're appearing only as fact witness and not to represent the applicant. So that's one little really tedious little detail, but it's something that I have to wrestle with.
Raz, while you're going through that,
Yeah.
in your experience, what has been the most common mistake, error, poor choice of judgment that you've seen repeatedly at this level with boards of adjustment? How can we avoid stepping in something that everybody else is
Right.
stepped in?
I have not done that many cases before boards of adjustment. I sit with the Raleigh Historic Commission, so I've seen a lot of what they do. Some of the lessons apply, a lot of them don't. I think the board, the members of this group sort of working with one another respectfully, having a sense of the decision being a unified decision of the board. If a point is of particular concern to individual member, be perfectly at liberty to hold fast on that point if you've got a perspective or a viewpoint. By the same token, the name of the game is sort of sizing up the way it looks like these cases are headed. And, and there'll be a vote taken, and it'll go one way or the other. And then understand that is the board's decision. That is the decision. And not everyone will be pleased with every decision. There'll be some minority votes, dissenting views. But I have seen some board members get a little overwrought, I guess is the way I'd put it. And that's just as an outside observer. And if I were caught up in a case, I'd probably be have just as strong feelings about, an issue as anyone else. But that together with having patience with yourselves as you go through the findings and conclusions, because it's tedious. And I think I made the point before, in a court of law, judges do it in chambers, or they ask a lawyer to prepare a set of findings and an order for them, and having to do it on the fly as a committee, putting together the details, once reaching consensus on the details, then committing it to writing and deciding how you're going to phrase it. In the public view.
So you're saying, just to paraphrase it, sounds like maintain harmony, make a decision, move on,
Yeah.
and
It's,
have an appearance of collaboration, if nothing else, in a public eye.
yes. And don't worry about the fact that the coming to a decision and agreeing on findings and conclusions is going to seem clumsy and awkward, because that's just unavoidable.
Yep.
That is unavoidable.
Yep.
And I make the pitch to, maybe I'm talking to members of the public, seeing how crazy things seem to be or inefficient. I'm saying, that is committee decision-making in the public in action. It is utterly unavoidable. And what you should take from it is that everybody here is very conscientious, that they're working so hard and sharpening their pencils and trying to knock out challenging work without pay. But yeah, that's a dynamic that I think a lot of folks sort of forget about your work. It's been an hour. Is that about what you all were expecting? I'm happy to take any more questions or not, but it's been a full hour.
Any questions for Raz?
No, I got mine.
Next one.
Yes, sir.
The rules of procedure, we do not have a set rule of procedure for this board.
Right.
So just to touch on, some of the examples you gave us are very helpful. And I was just wondering what your opinion is in just incorporating some of these things. Some of them are not set up exactly the way I think that we would like to do this, but I think that should be on the agenda at some point in time soon, is to get through this and to establish something that we can follow and know a program for.
Agreed. And Kelly Chase and I discussed this together as I was driving over here this evening. And we agreed that if you would care for us to just take the 2 or 3 that we have, I think I printed out the Asheville one because it was more, we've got Asheville, we've got Raleigh, we've got Cary. And if you would like for us to just knock out a short and sweet, condensed, downsized version of that and just suggest very brief set of rules, happy to do that. And it's not, it's not rocket science. I mean, it's pretty easy to just say, well, okay, if this works for a 1 million population city, this probably would be a better fit for city the size of Clayton.
Something with simple language,
Yeah.
plainly stated without a lot of legalese would probably be a good thing.
Of course.
And the only thing I'd ask is if we could get that in the Word doc format.
Sure,
So if we have
absolutely.
questions or comments, we can actually post it for everybody's review.
And we could style it as a draft with comments in the margins, pointing out options or explaining
Sure.
this was our recommendation, but you may want to consider a different approach, that kind of thing. It would just be a stage setting kind of a draft. You can use it just to prompt conversation.
That's very much what I was, envisioning, Raz, that we would have like a draft
Right.
that we could have as an agenda item at a future meeting, take into account comments, and then ultimately we could adopt those rules by formal vote, and we could formalize it. So that sounds good.
I agree.
Yeah, and I would prefer to have the lawyer what you said about LLC or something, kind of maybe not a part of that. I don't know if y'all agree or not. But you just,
Well, we've got an intern, we could put him to work on this and knock it out in no time. It's not a challenging assignment.
Yes, yes, absolutely. Is that all, Raz? All for us?
Mr. Chair.
That is everything, I
Okay, sure.
noted to.
Yeah, and I would just say, for the benefit of the board, Raz and I talked probably an hour yesterday, and the procedure that he has brought forward tonight is very consistent with what, obviously, the planning board has been carrying on the duties of the Board of Adjustment for the last 3 to 4 years. It's very consistent with what we have been doing. And so just for the benefit of the board, we're not really recreating the wheel here. Very consistent. And I don't know that Raz realized yesterday when we were talking about discussing each one of the findings of fact individually, but he had suggested that, but that's exactly how we have been doing it with the planning board. So it has worked well with us. So just to let everyone know, I think what Raz has put forward has been tried and tested here in Clayton, and it works very well. So, sure thing.
Dick Hales from the planning staff. I certainly endorse everything Attorney Raspberry's passed along to you. In terms of things to watch out for, and I know he touched on this last time, but there's been an expanded description of conflicts of interest for board members and other parties that might be involved, including staff. And I know that my experience of working with boards is that is a difficult topic for some people to bring up. Matter of fact, some people view it as, you know, if they live 2 houses down from the location of variance, if they bring it up, they feel somehow ashamed or embarrassed by it. So one thing I've just noticed, given the 160D requirements from the state, added a lot more detail to that. Like it talks exactly about what constitutes an immediate family member. We didn't used to have that, and things of that sort that try and encourage board members to feel comfortable about bringing that up in advance, calling the attorney to talk about it, so it's not left to a more pressure-packed decision at the hearing, whether you're allowed to vote on the matter or whether you're being recused. And of course, if we know someone's being recused in advance, then we're more prepared to seat the alternate, things of that sort. But that's one thing I've observed a lot of board members put pressure on themselves in the past, and sometimes not necessarily. It's something that is a part of being transparent and living up to responsibility on serving on a public board there. So just wanted to add a little emphasis to that. Francis went over that at your last meeting.
Well, I couldn't agree more. And the new rules, it's a point of emphasis in 160D in the revision. It applies to staff. There's language now about staff members that might be introducing cases and presenting evidence to you. Something that you could consider having a more fleshed out conflict of interest provision. I did one for the Raleigh Historic Crowd where we adopted the state minimum standards, but then we provided opportunities for members to ask to be excused from voting, even though they might not technically be involved in a conflict of interest under the state statute, but they felt it might be an appearance of a conflict of interest. And so they would request recusal in the board's discretion, which was usually granted just for the sake of an appearance. I think I gave you all the state statute, the minimum standards. If not, I'll get them to you. It's nothing profound, but it's direct financial or personal interest that's defined and elaborated upon with the applicant in the case, or any party having standing in the case.
Disclosure is a related topic, that if someone has conferred with the attorney ahead of time and they agree this doesn't represent a conflict of interest, disclosing that fact, particularly if it's some information known publicly, like you used to work for someone or something of that sort, is another way of instilling confidence in the process for the general public.
Yeah, the member doesn't have to request to be excused. The disclosure is first part. The second part is that I wanted to get that out in the open, and notwithstanding that, I do feel that I can I've been told by the lawyer that it's not a conflict of interest under the statutes, and I feel that I can fairly sit and hear the case, but I wanted to make that disclosure. That's another option.
Very good.
Is there any value in adding those standards from 160D to the rules of procedure, just so they're right in front of us?
Sure. What I did in Raleigh was I had a conflict of interest policy that was referenced in the brief or rules of procedure, and it restated the minimum, the required standards by the statute, and then fleshed out, the other opportunities for disclosure or a discretionary recusal. Sure, that's perfectly legit, I would think, appropriate.
Right.
And I will say, Dick and Jeff probably know 10 times as much about this process than I do. So I am your attorney, and I was asked to make a presentation, but they have a lot more experience in all of this than I ever will. So I didn't mean to make it seem that they probably should be doing the presentation and not me for training, but I was tapped.
I thought the question earlier about how do these cases typically go and was interesting. I certainly think back to, it's been a trend the last 10 or 20 years of people successfully suing cities because one of their boards, like a Board of Adjustment, made a decision on a matter that was felt to be arbitrary and capricious. And of course, that oftentimes means it got a neighborhood up in arms and they all turned out. For example, cell towers used to be a special use permit in a lot of communities that might end up at the Board of Adjustment, and when there's a room full of neighbors there in opposition, it makes it tougher to stick with the findings of fact and to keep out sort of not in my backyard sorts of comments. A lot of those things don't come to you anymore. Also, other controversial land uses relating to big factories and other things, most ordinances now have a standard, like a minimum setback of a factory from residential areas and things like that. So I don't want to jinx it by saying they're not as controversial as they used to be, but it only takes one person too close to a neighbor to turn a neighborhood out sometimes, but not as difficult issues as some of them that used to be faced by boards.
Thank you, Dick.
And let me add to that. I'm sure you all will have cases that are somewhat controversial where neighbors and others may want to speak, and it'll be largely just to say that they are 100% for this proposal or against the proposal, and they may offer an explanation. And I think most boards, most quasi-judicial boards feel an obligation to let interested citizens who show up have a say within reason, even though what they have to say really doesn't go to the business of the findings that you have to focus on. Right. But it's a safety valve, and it's just a reality of public tribunal like this. Right. And if you have so much of it and it's overwhelming, a reminder that the board, and I've seen the chairperson just, if you get the 20th person at the podium saying the same thing, just basically being a plebiscite, being a cautionary comment, or at some point you may have to.
I was looking at some YouTube videos across the country of different Board of Adjustments, and one of them, they had a clock. You had 2 minutes, and the clock is just, and when the 2 minutes is up, then the people could see it as they kind of knew, and some would still try to go on, and then they would cut it off.
The only tricky part about that is it's sort of black letter law that time limits in a quasi-judicial are not acceptable in a quasi-judicial forum. City councils, town councils everywhere have time clocks on, limits on members of the public appearing and just offering a matter of concern, having their time at the microphone. But in a judicial setting, the parties are entitled to make their case, and so a more or less arbitrary time limit is not going to fly in a quasi-judicial. If you are going to put time limits on folks, it would normally fall to the chair just to control the hearing by requiring every speaker to get to the point, to avoid repetition, and to introduce only relevant evidence and relevance as to the 4 standards that you're looking at, and to control the hearing that way. Just a set time period in a quasi-judicial forum is a problem. So I would offer that. It's a very, very definite legal distinction between legislative hearings and evidentiary hearings.
Well, I think that's it, is that you have to, there's a distinction between opinion and evidence, right? And often the public opinion is what's going to be what you hear with multiple people coming up and voicing their concern. It's not necessarily evidentiary, but it's an opinion.
But if it's a citizen that lives in like a neighborhood or so and they see traffic issues already, or they see accidents, I mean, they can come and talk about that, correct? And that's factual versus just an opinion, is that right?
They can, and you know, in a court of law, lawyers argue the law, and witnesses testify as to facts. And there's a fairly bright line between those two roles. And in a hearing such as this, where you don't have a lawyer, you'll have a speaker, and they'll just start testifying, they'll start speaking, and the distinction is gone. You really, lawyers are hard pressed to decide, well, did he say that? Was he making an argument, or was he really trying to make that statement as an opinion with respect to some matter of fact under consideration? So, you know, it's challenging, which is part of the reason why most of the time in these hearings, just about everything comes in within reason, because, you know, a judge or a lawyer would have a hard time ruling on whether evidence is admissible or whether it's just he's just making an argument, because it's all glommed together by the person that's speaking.
I think reminders from the chair on hearsay, someone speaking on behalf of other persons who aren't there is a good reminder. And also if they stray about more wide-ranging objections instead of land use compatibility, which is really the legal basis for all zoning, that's a good one to put a reminder on as well.
Yeah, I really didn't get into the, you know, admissibility of evidence and those kinds of procedural calls. The chair rules on whether certain things should come in or can come in. You sort of have to take each case as it comes to you and apply the rule of reasonableness on the most of the time. If your agenda's not too full, you'll have a fairly flexible feeling about what comes in. But at some point, if it gets to be repetitive or just gets to be a popularity, you know, matter of whether 10 people want it and 10 people don't want what's being proposed, you have to caution the speakers. And you mentioned the business of traffic safety. Generally, under the law, the strict rules of evidence don't apply. The board has a great deal of discretion to decide what comes in. There are 3 exceptions in the statutes that require, even if there is no objection from any of the parties on the other side of the table, to the admission of and consideration of certain evidence. Property value, diminution in property value, traffic safety, and what else? There's a third one. It's in the BOA law, and I'll send you something on that. But there are 3 categories of opinion evidence that require expert testimony. So opponent to a variance request, when traffic is an issue and safety hazards are an issue, can't just expound forth on, I know this is going to be a dangerous intersection, it will cause all these kinds of problems. That's generally the kind of thing that the statutes say, nope, that to be considered evidence along those lines needs to be presented by a qualified expert, not just, and likewise, property values. My property values will plummet. No, you're supposed to have an expert witness to testify about land valuation.
Of course, it's not at all unusual for one appraiser offering evidence on impact on property values to be followed by another appraiser representing opponents who will give a diametrically opposed opinion. Both expert opinions, however.
And that's, it's, the statute just got changed because some folks lobbied for that. The real estate appraisers wanted to have that higher standard, but like I say, the rule of reason, and the main thing you need to be concerned about, if evidence comes in that's just wildly far afield, that's not going to be reversible error normally. What is of concern is if a piece of evidence that is pivotal to the crucial finding that you have to make is not evidence that would be admissible in a court of law. That's not compelling evidence. So you can have a surplus of bad evidence, but what you really want to avoid is having your decision have a piece of bad evidence be the linchpin of your decision. Easier to just, preach that, but it's a little more difficult in the application. Documentary evidence, all documents are hearsay unless the author is here to respond to questions, will be cross-examined. Most boards receive documentary evidence if it's in the normal course of business and if it seems to be authentic. Sometimes if it's pivotal in a case, the options already require the author to be present to appear in person. Normally, it's just too burdensome to require that, but sometimes it's appropriate. I have offered a cautionary instruction if a piece of evidence, it's a document, is really pivotal, is to just say, think very carefully about the credibility that you want to give this evidence because the author can't be cross-examined and the weight that you want to give it in your case. And it cleans up the record, sort of sanitizes the record. If you have an appeal and a lawyer's made a cautionary comment, sometimes that covers the basis. It makes the case on appeal a little stronger, even though you allowed evidence that just would never come in a court of law. Because you're not subject to those stringent requirements by statute, and with few exceptions. Okay.
Well, thank you. Yeah, and I would say too, Raz, I found it good practice on the expert witnesses to have them to state their qualifications. I would assume you would agree to that?
Oh, absolutely. Oh, absolutely. That's part of laying the foundation to be qualified to testify.
Right, gotcha, thank you. Okay, yep, absolutely, new business. So Jeff, you're a new business.
New business and another topic for the board to discuss, and I'll be brief for the sake of time. So Jeff Keynes, Senior Planner, Town of Clayton. First of all, I would like to apologize for not having a hearing tonight. We will rectify that immediately, so you will have a hearing next time. So we apologize for that. This will be taken care of quickly and swiftly. Second is, for full disclosure, I did have a nice conversation with Chair Mazzell. The question is recommendation. Recommendation, there's two types. Recommendation from staff. Does staff recommend approval? Does staff recommend denial? Second type of recommendation, if staff recommends approval, we have recommendations for conditions of approval. And so we touched on it briefly. To my opinion, there was no consensus of which the board likes. I have done both, of leaving it open, and I've also gave a recommendation of approval or denial of an application. And with an approval, we've also given conditions of approval that should be attached to this application if approved. So I just want to pose that to the group for everyone so they can hear it from me for discussion purposes and give staff a direction. I know it's getting late, almost 7:30 now, so it doesn't have to be held, this is tonight, but we would like some sort of direction on the future of how you want to go. We can attach it to this next hearing for the parking variance coming up, or let this one be no recommendation and hold it in the future. So that I'm going to hand it back.
Yeah, thank you for bringing that up, Jeff. And I will add to that Raz and I also had a conversation about that as well, and would like to just present that to the board to get your feelings on that. Raz and I think agree, correct me if I'm wrong, that it would be our preference that staff not make a recommendation to us. We have a staff report before us tonight, which I think is very well done, where we have staff analysis of each finding of fact. And I think it takes staff out of the decision-making, swaying us, or it could be persuade that or perceive that staff is swaying the decision. And so I think with the staff report as you have prepared, which is very good, Jeff, I think, and correct me if I'm wrong, Raz, that we would be okay, and we can obviously agree here at the board to not have a staff recommendation, but have a very detailed staff report as you have already prepared for this item tonight. So.
Let me just add that one point on that. I think it is the board's call whether they request that staff make a recommendation or not make a recommendation, say in only those cases where staff feels strongly compelled to make a recommendation, and particularly those cases where special conditions might be the kind of thing that the staff input would be appreciated. I mean, the staff decides whether it wants to do this or not. Just because they're entitled to offer testimony and to present evidence relevant to the issues in these cases. And the finding number 4, whether the granting of the variance would be consistent with the spirit and purpose of the regulation, that's one particular standard where I can see that staff might be very interested in letting this board know, and you all might be really interested to hear if the staff thinks that a particular variance request is really inconsistent with their understanding of the spirit and intent of a particular provision of the code. So with that particular, that is an example. I don't want to say, we've agreed and that's an opinion that applies in all cases. I think the general practice is for staff to take, I know Raleigh's practice is for staff to make a recommendation only in those particularly compelling cases where there's a feeling at the staff level that the board needs to know how the staff feels about a proposal. And of course, this is just variance cases. Administrative interpretations, those are an entirely different kettle of fish, because the subject matter of the hearing will be, are you going to override the staff's decision on an interpretation of the code? And you'll definitely want to hear their view on why they interpreted it a certain way.
Just to follow up with that, on the 4th point here, there is a staff commentary on whether or not it meets the letter and spirit of the code. There is a commentary, which is different than a recommendation for approval. I think you're asking about whether or not we want to have a staff recommendation of approval, because I invite the commentary on each one of these points. I think that, to your point, that's very, very valuable. But I think the heart of what we're asking here is whether or not there's an overall recommendation for approval or denial. Right. Is that correct?
Right.
So if we go with the general not having any recommendation, but then we decide there's a case we would like a recommendation from staff, do we have to do a continuance then, or will the staff, can we ask the staff at that moment or that certain hearing whether they give a recommendation or not?
Well, I don't think you've got procedural rules that answer that question, at this point. And I'm not sure I understand the difference between a commentary and a recommendation.
Okay.
because I think,
You are our attorney, I'll take it.
well, I'm just,
This is what I'm talking
yeah,
about.
I'm sure I've seen this. Yeah,
It's a common-
this is on the case, okay.
Right.
I would say, sure, maybe Marty.
Well, I think it's, honestly, I think
Until maybe the other two.
it's mostly a semantic
Talk about.
distinction, because this obviously is a case that didn't get heard. Proposed variance meets the purpose of the UDO. That, to me, is right on point.
But I think there's an overall, the question is whether or not it should be approved, period,
Yeah.
right?
Yeah.
And whether the staff is going to give a recommendation on overall approval. That's really what, on the individual points, I think the commentary is very valuable. I think that's correct.
Right.
And also my experience, if we have 4 criteria, I can agree with 2 of the criteria and disagree with the other 2 of the criteria. So you mentioned the commentary, does it meet the spirit and the letter of the UDO? I can say, yes, it does. It meets the spirit and letter and give my thoughts behind it. But on the first one is, did they make this issue of their own doing? And I can say, yes, they did. Therefore, they don't meet the criteria. So I can have, I don't want to say it's a 2-2 tie, but at the very end of the day, we have to outweigh, do they meet this more yes than no? And for folks who are not legal experts like yourself, to say, well, I can see it both sides. What do you live with this every day? You've met with the applicant 15 times, and this is what you do on a day-to-day basis. What do you think? And I can say, well, I recommend approval of this because of these reasons. Or I can say, I don't recommend approval. I think the applicant didn't prove, they didn't prove their case. Or I can say, I don't know, that's what you're for. And that's what some boards have said, no, we want to take on that ourselves, is we want to decide what is appropriate here. We just want to know the facts and your general thoughts, but that's nice because we've all heard arguments. I mean, let's be honest, in the legal sense, what attorney is right? Well, your attorney. Well, that's what the judge is for, and then you go up and you go up and you go up, and at the end of the day, we find out whose attorney is more correct than not. And that's what as Raz pointed out at the beginning, you are the judge and the jury and decision makers. So the question is, here are the 4 criteria. Here is my commentary or my thoughts on it. Do they meet it, yes or no? And I write about it. And at the very end, the very last statement, staff recommends, and in some jurisdictions that I've seen, it's in big bold letters, staff recommends approval or staff recommends denial of the following application. And we don't necessarily have to give a reason why. We just say, this is our recommendation. And if staff recommends approval, we recommend that these following conditions are adopted as part of the project. And we give conditions of approval, and we survey different departments and internal staff reviewing this and say, must submit a DEQ permit, must go for building permits, blah, blah, blah. And we have 10 conditions of approval, or if it's denial, it's denied. It's straight up than that. So the question is, we've done it different ways. I've heard a board member said, no, we want to hear your recommendation because I'm just a person who wants to volunteer my time and I'm really interested. But my God, I can't imagine doing this for 9, 10, 15 hours a day. I don't know what you guys think. And the other half is like, no, this is what I want to do. This is our decision. So we just want to, get some clarification from the board and try to be consistent throughout. We don't want to cherry pick what's your opinion on this project, but no, we're going to form an opinion on this project. We want to be consistent as we write these staff reports, because as we go through this process, especially with variances, it can be subjective. It's very, it's hard to be objective unless it's a 1 or a 0, as a former director would say. But we also want to build consistency so we're not arbitrary capricious of picking winners and losers. We just want to say, here are the facts laid out. What does the board think? And I guess if the board has latitude, you can use that as I ask staff, what's your recommendation? And we can give us 2 seconds to go recommend X or Y. I don't know. Or do you want it in the staff report? or not. I mean, and that's why I want to kind of pose the question now. I mean, I don't need an answer necessarily tonight because we've already wrote the staff report as we have spoken to leave it neutral for this discussion to take place and to get back with us. But we just want consistency as we write these staff reports that we know the direction of the board. That's why we bring it up. And then also for the conditions of approval, how you want to hear them. So I don't expect an answer tonight. A nice, robust discussion is obviously great. But we just want to make sure we're doing what the board asks us to do in these types of situations because some have more knowledge than others, so.
Sure.
Yes, sir.
Perhaps a hybrid approach. For me personally, thinking through this as you're hearing everybody's perspective so far, in the written materials, I like what we got this time. I like the commentary, I like getting the perspective, what you've seen, et cetera, but not a formal recommendation. Because what I'd like to do, looking ahead of time at the written materials before the meeting, is in my mind, come to some sort of perspective on it. What's there, what's missing, what do I think? So I'm making an independent decision at that point. Then I come to the meeting as a board member, hear your testimony as staff, hear the applicant's testimony, and then how does that alter what I came in with as my initial perspective? Does it change it? Does it not? And at that point, I'd be perfectly comfortable hearing any recommendations you have, any conditions, if approval was being considered, because we're going to hear, I would suspect, similar types of requests from the applicant themselves. So now there's more parity in terms of I haven't been influenced ahead of time. I've been able to draw my own conclusion. So that's what I'm thinking.
One thing to keep in mind, and thank you for your thoughts on that, is if we're going to prepare conditions of approval, and I believe it's a state law, because this has been our practice recently, is that we would prepare conditions of approval, send them to the applicant for them to review first and sign that we agree to these conditions of approval. So we're already prepared for, if we're going to have an approval, we would already have this conditions of approval already done. So we, for your hybrid approach, I understand what you're saying. I think that's a great direction. We can give our thoughts on it. And if you decide yes, we can say, here are the conditions of approval already reviewed by the applicant that are signed and negotiated, if you will. Okay, here they are, and we can hand them out immediately, or usually they're handed out with a staff report, or we can leave it blank and make the decision, but in the back pocket, if you will, say, well, if you approve it, we recommend conditions of approval. Here they are, and you can review them on the spot, but they've already been written by the staff and reviewed by the applicant and signed by the applicant. So I just want to make sure that you understand that.
So just to clarify, you would give the applicant the conditions of approval, but we wouldn't see them? Is that what you're saying?
Well, that's my point with Mr. Perricone, is if we are going to leave a neutral, and then you say, well, we want to approve it with conditions of approval, I mean, do you want them on the spot? Or we usually attach them to the staff report.
Yeah.
And that's what we're saying. If you choose approval, here are the conditions, or neutral, not. I mean, that's
So, correct me if I'm wrong.
going to be an easy yes or no.
Yeah.
Correct me if I'm wrong, but haven't those been amended, added to at the actual meetings themselves? Watching probably far too much YouTube of Town of Clayton meetings, it seems to me I remember that occurring, so that something's come up in the course of discussion at the meeting itself, and a new condition of approval was.
Absolutely.
Right, so thinking with that, obviously the applicant didn't agree to that ahead of time because they didn't know it was coming. So is there, I guess what I'm asking, is there really a legal obligation for the applicant to have that ahead of time, or that they accept it as part of what occurs at the meeting? And as part of getting the approval?
Let me just add something on that topic, because it's, there may be a little confusion. The Board of Adjustment, in ruling on a variance request, may deny the request, may approve the request, or may approve the request conditionally, that is, approved, but imposing as part of the approval some mitigating requirements. The thinking, of course, is that we couldn't approve this without some conditions of qualification, so we're going to say you need to put a buffer up here, or the wall only needs to be half as tall as it otherwise could be, or something like that. In the variance context, it is not required that the applicant consent to all the conditions, so long as they are reasonable. The reason for that is that the request could be denied outright. So a conditional granting of the request is a way of a cautious approval, a more cautious and guarded approval. In the special use permit context and in the site plan approval context, particularly if site plans are not set up in your code to be administrative, that is ministerial box checking. The legislature in the 162 revision was very concerned about cities and local governments in the context of approving those types of site-specific plans, requiring as conditions of approval things that might be slightly beyond the legal authority of the town or the city to, or the county, to require. So, and there are special statutes relating to conditions that don't fall within the garden variety site plan approval standards that cities are normally subject to. So as a way to keep cities and towns honest, if some of these conditions, and it arises again, site plan review and special use permit approvals, there are provisions in the statutes that the applicant needs to consent to those special conditions. That language does not appear in the variance statutes. So, you know, it's probably not necessary to have the conditions worked out in advance by staff and handed up to the committee in advance of their decision-making process, or the board, excuse me, in the variance context. It's always a good idea, and I think because of this heightened attention and sensitivity by the legislature to conditions, red line conditions as a review plan proves, that just are going a little too far, but the developer's not going to file a lawsuit to challenge the authority of the board. You know, it's just the dynamic, you know, what it is. So kind of the default is, well, let's just get all these conditions, let's get the developer to sign off on the conditions, the applicant to approve the conditions. Generally, in the course of ruling on a variance application, you know, it's not unusual for the board members, as you're talking about what your thoughts are on a case, to send a signal to a member, to the applicant rather, that you're a little worried, but you think you could approve the case if there were some mitigating conditions or special conditions attached to the approval. And it's perfectly wrong, I mean, okay to say, can we ask you to come up and we'll reopen the hearing, and what are your thoughts if we were to impose a condition like this? And you get on the record approval right there if it says, oh, I'm perfectly happy with those kinds of conditions if the general variance would be granted conditionally. And so everyone's in agreement on the record, and that's the way mechanically I think it sometimes comes out in the variance context. Obviously, site plan review, you've got 60 boxes to check. It's not such a straightforward kind of proposition. So that's just what I would offer in terms of approvals with conditions.
They're the basic ones, like you mentioned. If it's a setback, we may, you know, condition of approval maybe have extra plantings to vegetative shrubs to grow to a height of a minimum of 7 feet, or for example. Leave it kind of vague, but something because of a mitigating circumstance. But if the applicant says, yeah, that's fine, okay, we've thought about that, Because if there's other things, exactly what you're mentioning, can we just talk about it and do extra things? Absolutely, absolutely. As long as the applicant agrees to it, who am I? Or if you say, you know what, I don't think the hedge is a really good idea. I want to, okay, that's fine. It's one of those things that we do the best we can to think of it in the holistic context of an application. And sometimes there are things that people miss. And what happens is, and it has happened before, for example, and I'm going to go on the deep end here, construction documents. You know, please, you shall submit a set of construction documents to the engineering for review and approval by the engineer and the fire department. What if we forget it? What if we don't have it? And what if you guys forget it? It doesn't say I have to submit construction documents. It doesn't say that the fire marshal has to sign off on this. And we have run into situations where a fire marshal, you know, needs to review it. We go, well, it's not in conditions. So we think about these things as well, because, you know, it gets late. There's many things going on at the same time. And, you know, I don't know about you guys, but I'm starting to get hungry and I go, my brain's not working as it should. And we forget a condition. But during the course of this review, we start compiling these things and then review it. So the point is, we're flexible. You can recommend, not recommend. If you recommend for approval, here are some conditions of approval that we've already worked out. If you agree to them, great. If you want to add to it, perfectly all right and acceptable, as Ms. Raspberry's pointed out, that's fine. There's some basic things that are just standard conditions of approval. Shall obtain local, state, federal permits.
Well,
I mean,
is a standard, I'm thinking standard.
Yeah, yes, absolutely, yeah. And
They're always on it.
they're always on it, you know, and one thing that came to mind, that if it's a missed condition, a lot of times the UDO will back you up in that you have to require that anyway. And, you know, coming from the planning board, you know, we is constantly adding conditions and things like that. So I'm perfectly, you know, fine. I think what Raz has said is fine. As far as staff recommendation goes, do I know we're missing a couple members tonight. Do we want to wait to let them weigh in on this, or how does the board feel about giving staff some direction? Now, personally, I think what we have before us tonight for next month's staff report is perfectly adequate. Any changes that you guys see on that?
I agree with you.
I agree. I said we wait till we get the other two members here and.
Yeah, and I wouldn't recommend any changes to the staff report
No,
that you've already prepared.
since it's been continued, the staff report, everything's been out.
Yeah.
So there will be no changes to the packet.
Absolutely.
Until a full review and a hearing's taken place. It's just in the future, which direction
Sure.
you want us to go, which again, we're flexible either way. It's just, we would like some
Okay.
guidance. I've heard one person, they want our opinion, or another person, no. So, yeah.
Okay.
So
So
we'll find-
next meeting, hopefully we can give you some
No problem.
better direction, and we'll have all of our members here and can weigh in on it. So, but I appreciate that, Jeff, very much. One item, again, on not new business, directed more for staff. There was some discussion at our last meeting about the possibility of having a town email address set up for board members so that we can correspond from that email address. And I know, please weigh in, but informal discussions I've had individually, it seems like that is something we'd like to pursue as a board. Anyone oppose that? Everybody good?
I think that's a great idea.
Yep, okay. So, yeah, I guess we maybe direct staff to look into that for us. That'd be great. That's all I have for new business.
Chairman, if I could just make
Anyone else?
one quick comment about that.
Sure.
We serve as attorneys for the entire board, and if any particular member has a question they want to ask us relating to the business of the board, feel free to contact us on email. We will respond, but if it raises anything substantive, we will copy every board member with the correspondence, because it's all, we are not giving an opinion or offering any kind of assistance to individual members. It all goes to the board members as a group.
Very good. Very good. Good practice.
Related to that, in terms of the Open Meetings Act, asking questions via email with everybody involved, we're not, that's why when I asked my question, I didn't ask everybody, because I didn't want to find out that I'm violating the Open Meetings Act by asking everybody the question. So clarity on that, if you would.
Correspondence is fine. Obviously, you can't take any action, and you shouldn't deliberate conducting the public business via email.
Right.
There's not a bright line there, but I think you know it when you see it. If a question comes up, we'll respond to the question, but there probably shouldn't be a, multi-series back and forth that really looks like deliberation off the record among the group as a whole.
Very good, very good. Okay. Any other items we need to take up tonight? All right, I'd like to thank Raz and staff for hanging in tonight. And Raz, as always, your presentations are very valuable. We really appreciate your time tonight. So with that, I'll entertain a motion to adjourn.
Make the motion that we adjourn.
Got a motion and a second. All those in favor say aye.
Aye.
Opposed, like sign. We are adjourned. Good evening.